You are listening to CLAT Tribe. Welcome back to the Deep Dive. We are tackling the city edition of The Hindu for Saturday, January 31st, 2026. And I have to say, looking at the spread today, it really feels like the legal system is playing catch-up with reality.
It really does.
It's got the Supreme Court redefining the biology of dignity. We have doctors, people sworn to save lives, accused of plotting mass terror. And then there's this culture war on campus that is just flipping the script on who gets to be a victim.
It's a heavy day for definitions, isn't it? If you look closely, every single major story today is about a red line being moved somewhere.
How so?
Well, the courts are moving the red line on what the state owes a schoolgirl. The police and UP are being told very clearly where the red line is for using force. And at Delhi University, students are arguing about where the red line for discrimination actually lies.
It's a battle for meaning.
Okay.
So we're going to break down that landmark Article 21 ruling on menstrual hygiene, which is, it's huge for constitutional law sense.
Absolutely.
We'll look at the white-collar terror module targeting a coffee chain, of all things. And we will get into that really intense debate over the Sudama quota.
And that last one is just a fascinating study in how mythology is being weaponized in, modern legal arguments.
Absolutely. Okay, let's start with the Supreme Court. Justice Partiwala's bench has effectively expanded the scope of Article 21, the right to life and personal liberty, to include menstrual hygiene management, or MHM.
Right.
Now, we've seen the court expand Article 21 before to include things like privacy, clean air, even sleep. But why is this specific ruling about schools being considered such a paradigm shift?
Because it moves the conversation from sanitation to dignity. That is the key distinction here.
Okay.
Previously, toilets in schools were treated as an infrastructure issue, like having enough desks. The court is now saying that a lack of menstrual facilities isn't just an inconvenience, it's a direct violation of a girl's fundamental right to dignity. The judgment explicitly uses the words stigma, stereotyping, and humiliation.
That language is so crucial. So if the state allows a situation where a girl has to skip school because she doesn't have pads or privacy, the state is effectively facilitating her humiliation.
Precisely. And the remedy they've prescribed is what's known as a positive obligation. It's not enough for the state to just not discriminate. They have to actively provide.
What does that mean in practice?
The order mandates that all states and union territories ensure every single school government, aided and private,
It's a massive administrative burden, for sure, but one that legally prioritizes bodily autonomy over, budget constraints.
Exactly.
Now, keeping with this theme of the body and the law, let's pivot to Uttar Pradesh. Because while the Supreme Court is telling the state to care more for students' bodies, the Allahabad High Court is telling the police to inflict less harm on the bodies of the accused.
We're talking about the half-encounter phenomenon.
Right, this practice of shooting accused persons in the leg, supposedly to prevent escape. And Justice Arun Kumar Singh Deshwal, he did not hold back here.
No, he did not. And for our listeners interested in criminal procedure, this is a textbook application of the separation of powers doctrine. The judge noted that these leg shootings have become, quote, routine. He basically accused the police of usurping the role of the judiciary. He said the power to punish lies only with the courts.
He even speculated on the motive, which was pretty scathing.
Oh, yeah. He mentioned out-of-turn promotions and, maybe more surprisingly, fame on social media.
That's the 2026 reality, isn't it? Influencer cops.
It is. The court is saying that an officer's desire for likes cannot just override an accused person's right to due process. To curb this, they've issued new guidelines.
And what are those?
An immediate FIR registration after any encounter injury, and the statement must be recorded before a magistrate, not just another police officer.
That magistrate requirement is so vital. Under the Indian Evidence Act, a confession to a police officer isn't usually admissible, but a statement to a magistrate carries real weight. It sort of closes the loop on accountability.
It tries to, yes. It forces the police to justify their use of force in a judicial setting immediately, not months later at trial.
So we have the courts regulating the state. But what happens when the regulation comes from the University Grants Commission, and it's the students, specifically the general category students, who are the ones protesting?
This is the situation at Delhi University. It's about the Promotion of Equity in Higher Education Institutions Regulations 2026. Usually, equity regulations are welcomed by student bodies, but here the general category students are arguing that the regulations are, biased.
Their main argument is that the regulations see discrimination as Unidirectional.
Yes. They claim the rules just assume that only SC, ST, or OBC students can be victims of harassment, and that general category students are always the perpetrators. The protesters are arguing that in 2026, the hostility goes both ways.
And they want a mechanism to file complaints if they are targeted.
Exactly. And this is where the Sudama quota and the Dronacharya inversion come in. These cultural references are just flying thick and fast.
Okay, unpack the Sudama quota for us.
It's a retort, really. Sudama was Lord Krishna's childhood friend, a Brahmin, but, very poor. Students from reserved categories have reportedly been mocking the economically weaker section, the EWS quota, by calling it the Sudama quota.
As a way of saying,
you might be poor, but you still have your caste privilege.
and the counter-argument to that.
Well, the general category students are now using the story of Dronacharya, the teacher who famously refused to teach Eklavya because of his caste. A student protester argued, now we are being treated like Eklavya, we're the ones being excluded. They cited graffiti like, Brahmins leave the campus.
It's a fascinating and I imagine very volatile legal question. Can a regulation designed to protect one marginalized group be struck down if it fails to protect the non-marginalized from similar abuse?
That's the core constitutional question, right? Does equity mean special protection for some, or does it mean equal protection for all? The students shouting, "Tum jatvetsetadoj, hamashtravetsetadoj," you break us with casteism, we unite via nationalism. They're trying to reframe the entire debate from caste identity to national identity.
A very clever rhetorical flip. Okay, shifting gears entirely, let's look at national security. We have updates on the Red Fort explosion from last November, and the profile of the accused it's disturbing. We are not looking at uneducated, marginalized youth here.
No, not at all. We're looking at what's being called the white-collar terror module. 3 doctors, Muzammil Ahmad Ghanai, Adil Ahmed rather, and Shaheen Saeed.
Doctors. It just creates this cognitive dissonance. You train for years to save lives, and then you allegedly plot to blow up a coffee chain.
And the target selection is what really stands out to intelligence agencies. Their initial plan was to bomb a global coffee chain outlet, specifically because the founder is Jewish.
So it's global geopolitics manifesting as local terror.
Exactly. But here's a nuance. There was internal dissent. The doctors wanted the coffee shop. The car-borne attacker, Umar Anabi, he disagreed. It just shows that even within these radicalized cells, there's bureaucracy and, disagreement on strategy.
So what was their goal?
The goal was to revive Ansar Ghazwat-ul-Hind, which is an al-Qaeda offshoot, but they were struggling with operational consensus.
It implies the ideology is persistent, even if the logistics are messy. Okay, from internal terror to border politics, Assam is heating up ahead of the elections. Home Minister Amit Shah is back on the demography argument.
It's really the central pillar of the BJP's campaign there. He accused the Congress of altering Assam's demography for vote bank politics, and he used that very charged term again, guspify, or infiltrators.
The promise was very specific. Eject illegal immigrants one by one.
And in Assam, land and identity are so legally intertwined with the National Register of Citizens, the NRC. So when Shah says this, he isn't just making a political speech, he's signaling a potential administrative overhaul if they win. He's framing the election as an existential choice for the indigenous population.
It's a high-stakes narrative, for sure. Let's zoom out to the global stage. The India-EU Free Trade Agreement, we've been hearing about this for years. Is it finally actually happening?
It seems to be moving fast, largely thanks to France pushing it. But the detail that blew my mind isn't about tariffs, it's about the translation.
The translation.
Yeah. They are discussing using AI to translate the final agreement into all 24 European languages instantly.
That is huge. I mean, usually legal ratification takes months just because every comma has to be checked in every single language.
Right. And in international law, the text in every language is usually considered equally authentic. So relying on AI for that is a massive vote of confidence in the technology. It could cut the ratification timeline from months to literally days.
Provided the AI doesn't mistranslate a tariff line and accidentally start a trade war.
Well, that's the risk. But the political will is clearly there. The EU is pushing this because of the India growth story. They need access to this market. The sticking point, though, is still the CBAM, the Carbon Border Adjustment Mechanism.
The carbon tax.
Yep. The EU wants to tax carbon-intensive imports. India sees this as a non-tariff barrier. But the fact that they're rushing the translation suggests they think a compromise is close.
And speaking of automation and the economy, Ola Electric is in the news. laying off 5% of their staff.
Structural transformation is the phrase they're using. They're pivoting to a leaner organization that's driven by automation. It ties right back to that AI translation point. Whether you're a trade diplomat or a scooter manufacturer, AI is shrinking the need for human headcount.
A sobering thought for the job market. Let's end on a story that feels a bit more hopeful, or at least just deeply human. The interview with chess grandmaster Sarasadat Kadamal-Sharia.
Yes. She fled Iran in 2022 after refusing to wear the hijab. She's now playing for Spain.
And her comments on the situation back home were just so striking. She said the authorities cannot control it anymore, that women have simply stopped wearing scarves en masse.
It's a testament to civil disobedience, really. When a law loses its social legitimacy, enforcement becomes almost impossible. But the part that really got me was the anecdote about her son.
Oh, right.
She's navigating this massive political exile, learning Spanish, and her son comes home from school and says, "Quita, mama."
And she had no idea what it meant.
None. She had to ask a friend. It means get lost, Mom, or go away.
That is universal. You sacrifice your homeland for freedom, and your kid uses his newfound freedom to tell you to get lost in a new language.
It just grounds the high politics of migration in the reality of parenting. You're a hero to the world, but to your toddler, you're just the person in the way.
Before we sign off, a quick nod to the sports world. A historic day for Australian tennis.
Massive. Gadecki and Piers taking the mixed doubles title. The first all-Aussie pair to do it in 37 years. The crowd in Melbourne must have just gone wild.
And in cricket, Surya Kumar Yadav is being hailed as the world's best T20I batter by his coach. Plus, Mumbai's Siddesh Lad hit his 5th century this season in the Ranji Trophy.
The domestic circuit is incredibly healthy right now.
Yeah.
That kind of depth involves some serious discipline.
So bringing it all together, we've got the Supreme Court mandating dignity through chemistry oxo-biodegradable pads. We have police encounters being checked by due process. We have students debating the very definition of victimhood. And we have AI translating our treaties.
It all comes back to that initial thought we had. Red lines. We're seeing individuals, whether it's a schoolgirl, a student protester, or a chess grandmaster, pushing against the systemic definitions of who they are and what they're allowed to do. And the systems law, police, university are scrambling to update their operating manuals.
Which leaves us with a provocative thought for the weekend. We talk a lot about the rule of law, but in an age of AI translation, gender-fluid politics, and influencer cops, is the definition of the legal person, the very subject of all these rights, changing faster than the laws can actually be written.
That is the challenge for the next generation of lawyers.
Thank you for listening to CLAT Tribe.